Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doreen.
I'm Kiran Sanghera.
Welcome to Hull on Estates. You're listening to episode number 689. Kiran, tell us today what we're discussing, since you're the one that picked this great case from the Court of Appeal.
So today we're going to be discussing Roe versus Roe. It's a 2024 Ontario Court of Appeal case. It is generally about a will challenge. So it was about a deceased who died in... Sorry, give me a second.
No problem. She died in 2014.
2014, and the will was from August 24th, 2005. In her will, she had 4 sons. One of them was disinherited, whose name was Mark. And what ended up happening was, obviously, after she passed, her son Mark brought an application to invalidate the will on undue influence and testamentary capacity, and also brought an action. So the 3 sons who were involved, which were Rick, Randy, and Chris, could set aside any monetary relief that they get in case that the will becomes invalid. So in this case, the application judge ended up dismissing the application and the action on the grounds that the deceased she did not lack any undue testamentary capacity, and there was no undue influence. The judge did agree that there were some suspicious circumstances, but overall he didn't lack any capacity in making the actual will. Obviously, then what happened was Mark then appealed the application judge's decision and actually brought it in the case of trying to establish that there was an error in principle. So in this case, there were 3 sections that Mark brought the appeal against. So in terms of undue influence, Mark argued that the application judge erred by ignoring relevant factors for assessing undue influence, which is actually cited in a case in which I'm going to butcher the name.
It's okay.
Yeah.
Let's maybe take a step back, take a breath, and let's peel through this onion one layer at a time.
Okay.
I think you're giving our audience a little bit too many spoilers as well.
Okay.
But you're right. The appeal was ultimately dismissed, and what Mark went to court at the first instance to begin with was because he was disinherited. He has 4 brothers. His mother died. I think his father seems to already have been predeceased. And Mark was actually included in his mom's prior wills, but in 2005, he was left out, and ultimately that was the will that his mom died with. Mark actually had some pretty serious pre-death concerns about his mother's capacity, as well as about how his mother was sort of being taken care of and treated by one of his brothers, who his mother lived with, I think basically I think for the end of his life, or perhaps it was the brother who had always lived in the same house with mom. And so it's in that context that the court at the first instance did find those suspicious circumstances, because they had already been raised by Mark while mom was still alive. But Mark still ultimately lost a trial. The trial judge still found Mark's mom to be capable of having made her wills, to have been capable of disinheriting her son. And then Mark again was unsuccessful on appeal. But maybe let's start talking first about those suspicious circumstances.
Yeah, so actually what these suspicious circumstances were that at one point before the will, so in 2001, Mark and his wife, Mark, who had been disinherited from the will, actually raised concerns of elder abuse by one of his brothers, Rick, of the deceased, and they actually communicated this and escalated it to the police, which obviously the deceased found out and was not happy about, and actually was not pleased that this had happened. And then there was another circumstance in April 2003 where Mark's wife actually went to the deceased doctor to state that she needed some counseling and that she shouldn't be driving anymore, which the deceased then found out again and was not pleased about. And so the deceased thought, they're kind of conspiring against Mark and his wife are conspiring against the deceased, and that they're just making these claims that came out of nowhere sort of issue. But that was some of the suspicious circumstances. And then there was also the sworn statement. So at the time that the deceased wrote her will, there was a working diagnosis of early Alzheimer's. But while she wrote the will, a doctor actually gave a statement saying that although she's going through these early stages, she's still competent based on the knowledge of the deceased and was able to draft a will. And then at the same time, too, I know this is kind of going on, but at the same time, a lawyer actually commissioned a statement on behalf of the deceased, just citing the several reasons for why Mark was disinherited, which, like I said, had to do with the reporting of elder abuse, the pack of lies, as the deceased referred to it as, in which Mark's wife brought claims of counseling, that the deceased needed counseling, and that they were just causing her a lot of trouble. So those were some of the circumstances that the application judge appealed to when she was making her decision.
Right. So that is why the suspicious circumstances were found. But also you mentioned a lot of ameliorating circumstances where I actually don't see very often in my will challenges an affidavit from the testator explaining why they had disinherited a particular person. In this context, it actually sounded like there's a great idea on the lawyer's part, and it probably something that like the trial judge found to be persuasive, because obviously at the end of the day the testator isn't going to be there to explain why, and then at that point we're left with the lawyer's notes. But this time there's actually a sworn affidavit, which is actually like quite interesting to me. But at the end of the day, like this is a will challenge, so in terms of like the legal test of what a will challenge is, it is a very well established list of 5 factors that goes back to a case called Banks and Goodfellow. It is the same 5 factors that is applied to like all will challenges in Ontario, across Canada, even though like every case is going to be like completely different. They're basically like all snowflakes. Not all one of them are the same, but they're all snowflakes, right? So those 5 factors are, in order to be capable of making a will, at the time that the will is actually made, you need to understand the nature and effect of a will. That's the first one. The second one is you have to be able to recollect the nature and extent of your property. The third one is to understand the extent of what you are giving under the will. The fourth is you have to be able to remember the people that are expected to benefit, and where this applies, also may be able to understand the nature of the claims that someone might bring if they're being excluded from the will. So like number 5 could be a possibility where this testator will have to understand the possibility of a dependent support claim if he or she didn't include their dependent in the will. So it's sort of like there's like extra layers involved depending on what this person wants. Now, you mentioned on appeal sort of like the different grounds or parts of like the law that a court in Roe went into, and it's because in addition to these like 5 classic factors, Mark, the will challenger, also claimed that the deceased was under an insane delusion, that it's in itself a legal concept that I'll get into in a second, as well as that his mother was under the undue influence of Rick at the time that the will was made. So going back first to the insane delusion, you don't see insane delusions being alleged in every case. And I think typically will challenges and undue influence go together a lot more. And at the end of the day, you might actually just be left with a pure, did this person have capacity or not under those 5 factors? But insane delusion is sort of in a way a 6 factor where it is a pure legal concept. It's not an insane delusion in the way that like maybe delusions are defined psychiatrically. It has to be something that in the particular circumstances of this testator, no one in their quote unquote senses could believe in this thing, whatever this thing is. And for this one thing that like nobody else could have possibly believed be the cause of a particular testamentary decision. And for anybody who's actually interested in like the law on insane delusions, to read Banton and Banton, where Justice Cully like sets it all out. In insane delusions, I think because it is like so nebulous, like what is this one thing that nobody else under the same circumstances could have possibly believed and could have been like disinherited on that basis. I mean, like that's a really hard thing to prove. I like to think that, you know, like, I don't know, at some point in history, everybody thought like the earth was flat. And then now we really don't. But does that mean like a flat earther is like incapable of making a will like today in 2024? I don't think so.
I completely agree. I think it's just, like you said, it was a new concept that was kind of, or not new concept, but it was new to bring it into like a will challenge. And I see why Mark brought it in, but it's just, I think on the grounds of the actual case itself, it's hard to prove because
it's really hard to prove. Yeah. It's really hard to prove. And like, there are some like historic cases where like, I remember reading one where it was successful and it was actually like a Supreme Court of Canada level decision, but the delusion was actually about a wife's infidelity. And I was like, to me, in my mind, maybe being much more of a modern person, I was like, how hard is it to think that like nobody possibly could have also believed like the wife, you know, was or was not faithful? Like it's just then that it's so tough, right? The next one is undue influence. And so Kiran, I think I'm gonna turn this one over to you.
Yeah. So in this case, at the time that the deceased was actually drafting her will, and also during essentially Rick's entire lifetime, who was her son, who was actually in the will, they lived together, and Mark actually brought this appeal against him as well, stating that there was undue influence on the part of Rick when drafting the will. So in this case, it was shown that it was agreed upon that Rick did drive the deceased to the lawyer's office to change the will, and that was something that everybody agreed upon and knew about. But in this case, I think the application judge essentially rejected that submission by Mark, saying that there was undue influence. She stated that Beverly, who was the deceased, was able to manage her relationship with Rick, even though he may have been difficult to deal with, as Mark stated in his application. But she asked Mark, who was the person appealing this actually, and the disinherited, he cited a case, which I'm going to butcher the name on, Tate versus Gueguegirre. I will cite it in this podcast so you can read it, basically stating that the undue influence was actually part of the considerations within that case, and which is why it should have been proven that there was undue influence. But in this case, the appeal judge actually agreed with the application judge, saying that there actually is no set list of considerations when bringing an application like this to actually state that there is undue influence. It's on a case-by-case basis. And in this case, it was actually shown that although Rick, and this was cited by Mark, he had a difficult personality, there was actually no undue influence by Rick in drafting when the deceased went to go draft the will. And that was kind of the case. That was kind of that portion of the appeal in that sense.
Yeah. So at the end of the day, why undue influence when it's actually found will invalidate a will is because what undue influence is you're basically successful in proving that somebody had a proverbial gun to the testator's head to leave their will in a certain way. And so the testator ended up doing what they did because they had this proverbial gun to their head. It is essentially duress. It is being able to prove, like, but for somebody else actually exercising, like, just causing like so much fear in another, that like a particular action like wouldn't have been taken. And so that's why like the Tate list of points, and Tate is a divisional court case that now the Court of Appeal has said gives like a helpful list of points, is whether or not the testator was isolated, the failure to explain why certain family members are not named as beneficiaries, so actually like having like no explanation at all, the existence of inter vivos gifts, the circumstances surrounding the creation execution of the will, which, you know, like could in a little way like pull in like, well, who took mom to a lawyer in the first place, who found a lawyer for mom. And this is why you mentioned that Rick was the one who drove mom to the lawyer's office. But sometimes, like, you know, old people do need help. Like, people take their parents to like doctors. Lawyers are usually like not a very familiar thing for anyone. And so for someone to even like set it up, sure, that could be a suspicious circumstances, but you're going to need a lot more. And lastly, what's on the list from Tate is statements made by the deceased that he actually feared the person that the undue influence was alleged about. And again, this, as you mentioned, like was not a closed list, but you can get a sense of like why the court and Tate sort of like gave these particular factors, because it's really about like fear. It's like something you would have never done, except you've absolutely thought you had to do it. Otherwise, like you were in jeopardy, or like somebody else is going to be in jeopardy. In cases like this, like sort of like the more diminished your capacity is, so it's like maybe like the more advanced your dementia is, then like the less aggressive someone might have to be in order to like cause fear from someone who like might actually be suffering from like quite severe Alzheimer's. I'm just going to sort of end this podcast with like, it's just a bit of like a final conclusionary note on will challenge appeals in general. Like, they are actually extremely difficult cases to appeal. Will challenges at the end of the day, because it is so much about like the totality of the circumstances. You can see like how broad even those like 5 classic will challenge like factors are, that it's really all about those findings of fact. Here, the appellants tried to argue that the legal test, as it relates to like, well, legally, what is an insane delusion, and how should you consider insane delusions, and like the legal test for undue influence, and how you should like consider it as sort of like being like the entry points to say why this decision should be set aside. But, you know, because the law is like so well settled, but actually in a way so difficult to apply under all circumstances, it still ends up being more of a factual appeal than it is like an appeal of law. And so why they're often unsuccessful, even with perhaps like appellate statistics, like even factor in how all appeals are generally unsuccessful. Ian Hull actually has a blog on this case as well, which we'll link to, and that blog will talk more about will challenge appeals like in general. I also thought this case had like kind of an interesting comment at the very end about whether or not the testator understood his or her assets. And this is you do have a line from the Court of Appeal here saying that the trial judge was entitled to rely on the evidence of geriatric psychiatrists in determining one of the parts of this will challenge test. And in this case, it was that the testator had understood the nature and extent of her property. And of course, you only have to understand your property in a general way. You don't have to have an accountant's knowledge of your own property when you make a will. And so with that concludes our podcast. Until next time, I want to thank you for listening. I'm Doreen So.
I'm Kiran Sanghera.
Should you have any questions, please email us at info@hallandhull.com or contact us through the contact page on our website.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hallandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.